Hi, I'm Nicole Hemrick, and I'm the managing partner at Hemrick O'Malley, PLLC. Today, I want to talk about a recent policy alert through USCIS. This is from December 19th, regarding guidance on flexibilities available during and after emergencies or unforeseen circumstances. One of the things that has always been challenging in dealing with USCIS is there isn't really somebody that you can call or email if there's a deadline coming up and there's a reason that you cannot meet it. Luckily, USCIS has recognized this problem and has updated its policy manual to permit officers to consider these sorts of emergencies and unforeseen circumstances. According to the policy manual, the types of emergencies and unforeseen circumstances that may qualify include natural disasters, for example, hurricanes, wildfires, or other severe weather; national emergencies, for example, public health emergencies; conflicts abroad, or other unforeseen circumstances, for example, terrorist attacks, mass shootings, or other cyber attacks that may present unanticipated challenges to benefit requesters. That doesn't mean that those are the only types of circumstances that will be considered. If there is another reason that you require flexibility, you should highlight this in your submission to USCIS. What does that mean? So let's say there's a reason, either one of these that USCIS has outlined or another reason that you cannot file for a benefit in time. For example, let's say you have a visa expiring on January 6th and there's a hurricane in your area, and so you cannot send out the package to renew your visa to get to USCIS by January 6th. You would write in your cover letter that the reason for the delay was due to a hurricane in your area, and of course this was beyond your control. And you would ask USCIS to then please consider this fact and treat your case as if it is timely despite the fact that it has been received late. USCIS has discretion to consider flexibility in visa applications for extensions or changes of status. Extensions may also be considered if you entered under the visa waiver program, which typically only permits 90 days of lawful time within the United States, but there's some reason why you cannot timely depart that qualifies. USCIS has the authority to provide an additional 30-day period of satisfactory departure. Other circumstances where flexibility may be permitted is in the context of adjustment of status. Unless you are adjusting status through an immediate relative, that is a spouse, parent, or son or daughter over 21 that is a U.S. citizen, you must apply for adjustment of status while you are still in status, meaning you must demonstrate that you have been maintaining status the entire time up until the point where you apply for adjustment of status. There are certain exceptions to this. For example, people applying under the employment context may qualify under INA Section 245K for up to a 180-day gap in status prior to applying for adjustment of status. In the adjustment of status context, you can also demonstrate this flexibility under INA Section 245C, which is actually the no-fault provision for technical reasons for failure to timely apply for adjustment of status. Additionally, F1 and M1 students who lost status as students due to unforeseen circumstances or emergencies may request reinstatement due to such unforeseen circumstances and emergencies. Similar to visa waiver entrants, if you have been paroled into the United States, and the parole, of course, is for a temporary period, if there is an applicable unforeseen circumstance or emergency that prevents you from exiting the United States on or before the time that your parole into the U.S. is expiring, you may request a new period of parole from USCIS based on such circumstances. These flexibilities may also count in the context of responding to a request for evidence or notice of intent to deny. We saw this previously during the pandemic, where, as a general rule, everybody had an additional 60 days from the expiration date in order to file a response to a request for evidence or notice of intent to deny. Then that was taken away But now we see this again through the USCIS policy manual as a possibility on a case-by-case basis. If you have questions about this or any other immigration matter, check us out online at www.hemrick.law or give us a call at 833-848-7838.